Chat, we are going to get started today on day 32 at Karen Reed. But it's a bit different today. We have jury instructions are going to be discussed today. It's known as a charging conference where you start sorting this all out. Like, what are we going to tell the jury? Because they've heard all the facts, and now they're going to hear the law. It's up to them to decide how to do things. Well, you need to give them instructions. You need to give them guidelines. How do you want them to do the thing it is that you want them to do? Well, this is the way you do it. Hold on here. Drunk. Okay, hold on here. Not junk. Report, not junk. Why do people send me so much shit that's not junk? Why does it go to junk? Sorry, guys. All right. Okay, so am I from India? No, I am not from India. Sar. But anyways, this is the application of all of that. How do you have to give them the law. You have to tell them how to apply it and what rules and what they can and can't do. So now, jury instructions are critical. And I hope you guys understand that. This is listening to jury instructions get read in court, I understand is boring. But formulating and shaping them can make or break a case and can also lead to massive appeal issues. That's one of the biggest things that will get a case sent back or maybe even vacated, is that the jury instructions are bad. Still no Trump. I got home 10 minutes ago. I haven't even had, I literally had time to put on a shirt. I'll put him up in a second. But guys, this is the critical thing. These jury instructions are very, 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 very important. It's going to tell you what's going to be allowed to be argued and what won't be allowed to argue. So let's get to it. And thank you guys for all being here. My name is Sean, also known as Potentially Criminal. If you guys are new, I'm an attorney in the Cleveland area. Phil is saying the Pocklum livery looks good on the Ferrari. I can't wait. I'm going to have to do a model. I'll have to do a car model or two, and we'll have to put the Pocklum stuff on. And I'm not going to lie, Phil, when you put that out there on Twitter, I thought you were fucking around, and I'm like, he 100% did it. I was like, so here we go. Here we go, chat. Let's get to it. Let's get to this. Let's see. Okay. So we've got some time here to skip ahead. I mean, look at this, chat. Guys, look at this. I'm already, you're like, oh, wait. Is this? Are they talking off? Hold on. Are they talking off air? Something happened with this. Hold on, chat. We got to restart this. Something just went weird. There we go. I think that's up to.
On for trial. If the parties could please identify themselves for the record.
Okay, something was weird there. So we're gonna look at this, chat. We've already saved an hour. Look at this. Look at this. Look at this. We've already saved an hour of time. Hour and 15 minutes in, guys. That's what you get with me. We don't have to wait. We don't have to wait for all the fluff. So here we go. Let's do this. Let's do this.
You are unmuted.
Gotta watch the entire hour. We're not doing that.
Good morning, Your Honor. May I call the case? Please. For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin.
Fair enough,
Good
Bill.
morning,
Fair
Mr.
enough.
Malley.
Good morning, Your Honor. Hank Brennan for the
Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Okay, chat. This isn't working. So we're not going to bother doing it.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the
Can't say that, Judge
PowerPoint
Bev.
of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Wait, what did she just say?
So it is excluded. Rentschler would be K for identification. The PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence.
That's bullshit.
So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
It's one of Rentschler's slides,
We
guys.
are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing.
So, chat, this is the motion for directed verdict. They're not going to win. Nobody ever wins, and especially Bev, you're never going to win.
Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found. A dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th. When
I still think they should avoid all this stuff. Like, I know they do all this, but, like, this stuff is still not a winner in my book. Just go with, you can't prove she fucking hit him, case closed.
Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesado, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right. Thank you.
Thank you, Your Honor. The Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. Couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites, then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to do this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right, so regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right, you filed, I saw it in email, I don't have a hard copy of it.
That's Mr. Alessi's one.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time, so that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand
Yes, I did see Turtle Boy was found not guilty today. Suffer, all you anti-Karen Reed bitches. Suffer. Although it's only a protection order case, still Lindsay Gaetani or whatever your name is, suffer, bitch. But yes, we all knew that they were going to lose that motion, so now we move on to the jury instructions. Also, look, I love this look of like, it looks like the juror's box is full of garbage right now. But anyways, here we go. Here we go, chat, to the fun part. Let's go.
court's position might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking an instruction on murder wrong.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version I know that there was a lot of attention paid and some appellate decisions on the, each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear, okay? So I'll give you that, Ms. Giannetti. This what is evidence? I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden?
Chat, I'm sorry. StreamYard has been acting really retarded all day. Apparently, even Kirsha was having problems. So what they're talking about right now is arguing about the Bowden instruction. So a Bowden instruction is that had the police done their job, they would have found something better. Yeah, Gabe Hoffman, Chad. Gabe Hoffman and the Mossad got me. Anyways, they're asking for a Bowden instruction. And the idea is the police didn't do their job. And had they done their job, that would have revealed proper information that would have led to probably a different suspect. So that's where we're going with this. That's the argument they're making right now. Why did I miss Sean not wearing a jacket and tie today? I thought he was required dress code today. Sorry. Oh, was I deported? Yes. Gabe Hoffman. I know he's coming after everybody. So we're going to get going here, chat, but they're asking about the Bowden instruction. So here we go.
Instruction, I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and arguments are based or predicated in the case law on evidence. Not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or a third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Yannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials, active evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias, the investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it when we were prepared.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And
Well, I mean, you denied them the opportunity to bring in an expert who could talk about police procedure. The one thing I think, though, that Yannetti and Jackson and Alessi did not do right about this whole issue about police procedure, when Buchanan and all these guys were up on the stand, the one thing they didn't ask, and I think you guys heard me even mention at the time, they should have asked Buchanan, you were trained at the academy, right? About handling evidence. Yes. Were you trained when you became a detective about handling evidence? Yes. You received enhanced training, didn't you? Correct. Did what you do is what you did in accordance with those procedures? Were you trained that way? And they never did that. They've never gone that way. They didn't do it, and I'm very upset they didn't. Because if he had said no, I think they would be able to have then brought in their expert about police procedure. So, I can turn down my volume. I'm sorry. I'll turn down my volume. My bad. Hank would have jet to bed with a sustained, you know that. I understand that, but I'm sorry, chat. We'll turn it down a hair here. Is that better? Beautiful waterfall. She was never going to allow it, but here's the point. You don't ask for forgiveness, you ask for permission. You go down the road and you preserve the points for appeal. You make her say no. You make her go on the record saying this retarded shit. You make her do it. I've done that before with judges. I've made them go on the record and said, fine, judge, overrule this shit. Let the Court of Appeals know how fucking retarded you are. And I just stare at them. And they know. They know what I'm thinking, and I know they know what I'm thinking. And they know that I know that they know what they're thinking. And then sometimes they don't do it because they don't want to look like an asshole, dumbass. You gotta do it. Garrett says the leaf roller justice. The leaf roller probably wouldn't have been an issue. That would have been an improvisation thing. But like letting the witnesses get together, the improper handling of with the solo cups, like leaving John O'Keefe's clothes sitting for nearly a month, stuff not being properly logged, all the things they did not do, discussing your investigation with other parties like Proctor did. There's so much stuff they could have brought up, but they never did it. And I'm very disappointed. That would have been very helpful for Karen. She was never going to allow it, but you do. You go for it anyway. It's okay. You got excited. Yeah, sorry. Yes, Gina. Yes, I did see Mike from the Young Jerk stream Turtle Boys trial. Yes. And we're going to watch it probably this weekend. Because it looks like there's at least 2 days of it put together. I don't know if all 3 days are available, but I definitely want to watch it. I think it'll be good. If it works. So, appeals are for losers. Yeah, but that's why you fight for it in the meantime. You fight because you might win. You don't there's a reason why they play the game, because nobody's guaranteed to win. You have to earn it. Is that a verbatim quote of what? Joe Lloyd says I would keep you awake in class. Maybe. Carolyn says, I agree the defense did mess up their questioning in regards to procedure. I agree. Yes, and then I walk up and slap the judge and everybody claps. Yes. Yeah. Yeah, there's a lot they could have done. There's a lot they could have done. But yes, Turtle Boy got that dub. He got the dub, chat. So. Afix says the audio was trash. If you really want to stream, yeah, I'd love to stream it. It's a pretty straightforward case about the protection orders that he allegedly violated. So yeah, if you don't mind, I would appreciate that, buddy. Paul is in front seat. Paul is in front seat today. Oh, chat. Oh my gosh. Paul feel like big kid now. Paul back up front. Paul allowed to sit in sunshine again. Paul allowed to glare at Karen lady. Paul not like Karen lady still very much. Paul going for business casual today. No tie for Paul. Oh, there we go. Yes. Paul confused. Where was jury? Paul's about to testify, yeah. Paul make boom boom. Why am I... It's not letting me chat. I think this is frozen. Uh-oh. Can you guys hear me? Paul thinks he's a stud. Yeah. Okay, well, hold on. I'm stuck. Okay, let's see here. You know what? I'll just keep going from this corner.
And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here.
Okay,
I
good.
know.
You guys. Great stuff with the StreamYard chat. We're just crashing and burning on its own here, so yes. So let's keep moving. Let's keep moving. Let's see how long this goes. B. Jefferson, great time. No. StreamYard is just crashing and burning today. As Ghost says as well. So here we go.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, this clarification based on.
Yeah. So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
Just while we're on page 8, I just wanted to, Commonwealth does have an objection to the D2 instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Gianetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have. It would not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to the.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial.
Was Karen Reed allowed to leave? I mean, yes, it's at her house. Yes, her parents are sitting there with her. Could Karen Reed have gotten up and walked away? Could she have run out the door screaming? No. Two men with guns are sitting there talking to her. No, she's not free to go. That was not a consensual encounter. It definitely wasn't that. She was not free to go. That was 100% a custodial interrogation. So. Alessi tears down bad. I'm doing Alessi dirty. Bob can suffer. Bob can suffer like the best of them. Lolita says, could the defense team say they're pro bono in closing? I mean, like, I get what you're saying, but I have a feeling that Hank will cry and then Bev will stop him. So, no, they really can't. They really can't like that. And she had just put on a psych hold, yeah. Now, that's the more effective argument, is that she was involuntarily committed. We talked about this before, chat. When you were voluntarily intoxicated, like you get really drunk or you take a bunch of pills and you say things to the cops, that's not something that gets excluded. But if you involuntarily get intoxicated, that's another thing. And yes, she was involuntarily institutionalized shortly. Like, who knows what was still running through her system at the time. But I think that's something that got addressed early on in the case. And I think whatever it was, it turned out not to be a big deal. So, yeah, I don't think it's that big a deal right now. So, anyways, here we go.
We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So, yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add,
Sure.
They did seize her vehicle around the same time. So, that it goes definitely to the issue of custody and my client being able to not answer.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had known from the course of the day and from the statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have is placement, and as far as there's already been within saying requested jury instructions or requested main practice. And then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the main practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted any detail. And then when the questions became centered on, or more centered on details, at that point, and I know that's not evidence to the jury, but as the court is well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of the instruction. So I would ask basically that everything on page 8 prior to the voting instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not...
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language comes.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photograph,
What page you on? Okay.
one suggestion there was indicates now Commonwealth introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction.
Okay, chat. See, when she's talking about all these things, she's like evaluating the evidence. A lot of these are the basic bitch, and I hate to use that term, but they're the basic bitch jury instructions. So a lot of these are things that are already in there. But the good thing is they're allowed to do. No, guys, a croque monsieur, I don't like those. I don't like fancy sandwiches. I'm not a big Monte Cristo guy either. Your story be done, Bev. I understand, but the boating thing is coming in. No third-party culprits. So they're allowed to say the police didn't talk to Brian Higgins. They really didn't investigate Brian Albert, but they can't accuse them of the murder. And then the rest of this right now, we're kind of going on to the basic blah, blah, blah parts.
Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the part of that act being linked to the beginning of this text message.
all right, I'm going to take a look at that, Mr. Lessie. All right, consciousness of guilt.
Your Honor, Collins.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Your Honor, so the only,
1 second, let me just pull that up. Okay?
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these facts and circumstances.
Okay.
The Commonwealth view the first two prongs are essentially strangers in this situation and don't see explanation of the jury. Avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She did not intend to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
Sorry, chat. We need to go back here a little bit. Sorry.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm.
And chat, this is where we're getting back to the Karen Reed jury instructions from the murder part. So now we're talking about which, you know, I still don't think they proved murder, but hey. Sorry, chat. It keeps doing it. I don't know why it keeps doing it, guys. God, it's going to make the show a long time tonight, so. All right, so let me see here. Let me. Okay, let me see. I'm trying to bring up. Where is he? Because we looked at it last night. Oh. Let me see here. Where is. Crap, I can't find it anymore. But anyways, there's the three elements of this that. But anyways, here we go. Let's keep moving.
Just the third prong, he stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
She agrees. Wow.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really anyone who's good. But I understand, and I don't certainly want to.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe.
I wouldn't mind. We wouldn't have an objection to that.
Maybe I'll do that. But let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the.
If I alter it, it means I remove those two. That's all.
But no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right.
Yes, I have. Oh, Will, I've seen that happen before with jury instructions. I've seen that happen with one of the places I practiced where the judge allowed the jury to ask questions. And one of the jurors asked a question and wrote it down, and the judge brought us up when we were reading through the questions, and I said, I'm fine with it. As when I was a prosecutor, I was like, I'm cool with this. And the defense attorney's like, I'm cool with it too. And the judge is like, we're not doing it. And put an X through it. I'm like, then why the fuck did you ask me? Like, we both actually want this question answered. And he's like, no. I'm like, fuck. But yes, I have had it happen. Very good question.
Right,
Well,
I
thank
think
you.
that's it, aside from Mr. Lessie's motion regarding the exhibit. Right? Is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it, and I'd prefer not to have to deal with it, so,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem with this.
okay.
Just a couple other things before we get to Mr. Valesky.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We had to redact it, so we
Okay.
redacted. It's on a thumb drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, and I hand the
Okay.
proposed copy to the court.
Sure. Is it the same as last year's, but now with a...
It's different.
Okay. All right.
So you'll have a chance to digest that.
All right, chat, we're back. It's gonna be hard listening to Helene and Link go on, though. Yeah, they're practicing nationwide signal jamming for Saturday. Yes, if ICE deports me, why do I look Latin? Do I look Latino? Latino? Ay ay ay. All right, let me keep going here. T from Laos has probably got landmines in it. Laos has got that kind of a problem going on. Just saying. Gotta be careful, chat. Gotta be careful, little chattels. All right, let's try this again.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes. All right.
And I think I did mention that we.
Hour and 15 minutes is not that fucking long. That is a horrible amount of time for a month-long trial. You literally look like most Mexican politicians. I don't know if that's a good thing or not. Going back to my homeland, Niger. Oh. Zero is a new member. Thank you, Zero. I appreciate the support. Nice support tonight, you guys. Jim Cox gifting one sub. Thank you so much, guys, for your support. I appreciate it very, very much. Thank you.
Verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, believe I've given a copy to the Commonwealth. Can I hand
Okay.
a close copy to the board?
Sure. Is it the same as last year's, but now with a,
It's different.
Oh, thanks, Earl.
okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least it's like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court was given. Having said that, the verdict slip was used in this matter last year. The Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Lau, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy with it. But that may be somewhat helpful with the court's opinion.
Okay, was that on murder case?
It was not, but it had to do with a felony motive homicide.
Yeah, I'll take a look at it.
Mr. Kirk.
Mr. Kirk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip it provides the most clarity the other options. We think that this is simpler.
Hey, we're
it's
back.
cleaner, It's clear, and we believe that this verdict slip is the most
Doing that
appropriate.
chat.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any investor included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip was used in this matter last year. The Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Law, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy with it. But that may be somewhat helpful with the court.
Okay, was that on murder case?
It was not, but it had to do with a felony motive of homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy, please?
sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the consciousness field instruction. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to this argument to the jury related to specific areas which we would need judicial approval before we. So the two areas that are sort of listed within that we would like to make some argument.
Chad, I'm sorry. I can barely hear him right now. It's frustrating.
Jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips of the plate of her statements.
Okay.
In particular, would be the one where essentially she says it's significant to her.
Okay.
The exact.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over.
So what they're asking for is guilt of consciousness. And yes, Chet, there are times where if you flee the scene of a crime, that could be considered guilt of consciousness or consciousness of guilt. I don't see how here it is. She didn't do anything. Like, it's clearly she just drove off. But they're trying to use this against her. They are going really hard on the paint to get everything. And I think this is bullshit here. So that's what they're arguing, though. Consciousness of guilt.
I don't see that as being any evidence of consciousness.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be
Yes, so I did want to ask you though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? Okay. Okay, I just wanted to give you the opportunity.
That's interesting.
Okay.
That's
All right,
interesting.
anything
by
else?
Yannetti.
Anything
Wow.
else, Mr. Yannetti?
That's interesting.
We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the reductions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
Mm-hmm.
Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that.
Okay.
Right? 'Cause this is the-
Oh, it's just NNN. It's not,
Well, where did it?
no, it became 209.
So that
Our thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us
What?
know if the Wolf
I
PowerPoint
know.
is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth would submit is that the contemporaneous instruction was more than sufficient to recognition, and that it doesn't require any sort of differing language or further instruction given to the jury during the court final.
All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant. And I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error. To me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes
Sadly, this
occurred,
is
these
true.
cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this.
Ooh,
I'm
yeah.
going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you.
They didn't know because they didn't know the defense was going to fucking lie. They had to go back through and figure out what the fuck happened. Like, how do they know if they can't object in time? That's a little disingenuous by Bev. Also, real quick, 0 with 5 subs. Let's go, chat. Let's go. Whiskey 77 says, you want the truth? You can't handle the truth. Aaron says, I sound like an Irish Mexican. Well, there are those people. They formed the St. Patrick's Brigade during the Mexican-American War.
For raising that.
And then after we won, we executed a shitload of them.
10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical.
Yeah, but Bev's going to say you should have been like, whoa, stop. And yes, you kind of have to. You kind of have to go, whoa, time out. We have the right to inspect what you're showing. You guys notice that. And I feel like we don't normally talk about that because that's something we talked about a million times and kind of basic now for most of us out there. When you're about to show an exhibit, even if it's one unless it's already in the rotation, even if it is in rotation, you make sure the other side knows what it is. But if it's a new one, you go, hey, I'm going to show him this. Or you'll say, hey, I'm showing him this. And you just stick it on the table real quick and you're like, yeah, cool. Go ahead. Most of the time you're like, yeah, I got it. Cool. You're like, yep. And you tell him to go for it. But yeah, this is true. Nobody stopped him. Yeah, but Bev should do the right thing. Well, once again, it's kind of like where they both didn't do the right thing.
Nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen, mistakes can be made. It was recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to.
Yeah, but this was a big fucking mistake, Lally. This was a big mistake. Big mistake.
Offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To
Pretty
ask them
much.
if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right. So we'll see counsel in here no later than 8:30 tomorrow morning.
Sure.
We'll counsel here at 8:30. All right. Thank you.
All rise for the court, please.
Is there already one of these?
Well-
Like, are we swapping?
Yes.
Goodbye.
Goodbye. All right, chat. So that's it. A lot of stuff is gone. A lot of stuff is not there. Third-party culprit not coming in. The missing evidence, the spoliated evidence instruction. Karen Reed declined to go after it. But they are pursuing the Bowden one, which they're going to get. And then the second thing about lying about the sweater. I am really surprised they didn't make an objection today about Hank making all these comments, setting up the rebuttal, and then never doing the rebuttal. I think that leaves, that should have left an issue there, but yeah. So how angry could you be if you left a charge conference not knowing what the jury instructions are? Well, they're going to get an email to them later today, probably, and they're going to get them then. Lying about the hoodie's huge. Oh, it's fucking massive. So what, like, I know some of you guys are wondering, how does this work? I mean, believe it or not, like they're talking about like, oh, you only have a half hour between things for trial. I don't like, guys, you might like, I know, fat man jokes aside, when I have trial, I don't eat lunch. Like I might have a cup of, like, I don't like having food in me in case like I don't feel good or something happens. I'll drink a cup of coffee in the morning, like first thing in the morning, maybe I'll eat something, but like you don't eat lunch. I don't eat lunch. I'll go get a pop, like, get some caffeine in me, get a Monster or something, or a Rockstar, something like that. But other than that, no, there's no. I don't put like eating or having 30-minute time there is not abnormal. Better to be hungry than sick. Yeah, yeah. You get the itis. Well, there's that too. Bev still hasn't formulated them yet. Well, that would piss me off. But I mean, to be fair, guys, think about it like this. That trial I had at the beginning of the month of May. We got we do the jury instructions, we kind of worked on them through lunch and had them, and then the jury went. So getting them right beforehand, they kind of have a rough idea of what they're going to argue. I'm sure they're prepared either way. Most lawyers don't eat lunch, yeah. And you guys you got to eat. No, when you're in trial, dude, you are fucking amped. You are ready to go. You're running 1,000,000 miles a minute. Like I said, you'll have you'll have a bottle of water or coffee during the day or something like that. You're hauling ass around, dude. It's fun. You are not worried about eating. Get some gamer subs, yeah. So she's had multiple weeks. Yeah, but you don't prepare too far out. Yes, a majority of the instructions are already there because it's all basic. But every case has special instructions you fight over. Now, a lot of cases, it's always your fight. Most of the time, you're fighting over one instruction. The rest of it's basic. This is a lot more here. Keopathic says gamer subs Fat Man Slim. Yeah. Tofu Brains says just get Gatorade and protein bars. You don't need to really worry about Gatorade. I'd rather have caffeine than electrolytes. You're either too nervous or too high on adrenaline. Yeah. Yeah. But no, it's just if you drink a pop, Diet Pop, regular pop, whatever it is, if it's got taurine or caffeine in it, you're good to go. Karen says boot camp recruits don't poop for about a week or two. I don't believe that's true. I don't think that's true. I've heard things like that, but I don't think that's true. Plants don't crave caffeine. Well, that's why I'm not a plant. Is there a missing rebuttal instruction? No. Because that's your right not to have one. You don't have to have one. Now, as Mark Betterow put it, yes, regency and position. You are the last word. Us attorneys, you hear it every time Lally and Alessi and Hank fight. What do? We always want the last word. Your Honor, can I go? Your Honor. And she's briefly. It's Your Honor, can I go? Briefly. And then every time, we always want the last word. And here's the thing for Hank. I've seen prosecutors get up and give a 5-minute rebuttal argument. They have a witness pop up, and they basically say, do you believe any of this shit you just heard? No. Done. I've done that before as a prosecutor. Put my detective up there. You heard all this. Does any of this make sense to you? No. Thank you. Done. Hank didn't bother to do any of that. Hank just walked off. He took a knee and ran out the clock. That's not a man who thinks he's in a strong position. That's a man who's worried about fumbling the ball with 10 seconds to go. When you were in basic, 2 people from my group and about 10 total had to go to the infirmary to go to get something to make him go. Oh, no. What did the judge mean when she wants an earlier start time? She wants them there to we're going right away. They're going to be going early. Karen says week 2 before I pooped. Okay, week 2 does not mean 2 weeks. Day 8 is week 2. Day 9 is week 2. You make it sound like you got 14 days in before you can take a shit. Even then, I find that very hard to believe. I mean, I'll take your word on it. That just seems weird. So, Uncivil Law, Kurt, how you doing? Guys, Kurt, friend of the show. Kurt, if you want to pop on, well, actually, we're about to wrap up here. But anyways, you went on real quick. I'll send you a link. We just finished the charging conference. There we go. Trying to find it. If you want to come on in, I'm probably only be on for another short little while, but I'm well sure we need a stretcher. Yeah. Yep. I think so too, but it's We'll see, chat. We're going to see how this goes. I think Hank was too scared. I think he was far too scared to do a rebuttal. I mean, it makes sense. He got savaged. I don't think you guys understand how bad Hank got his ass whooped. Like, it was bad. It was really fucking bad. Like I told you, I was at court and attorneys were fucking laughing at Hank, just getting absolutely fucking leveled. It was a thing. It was a thing, chat. So, it was a thing. I was in court today, and this judge knew about the Karen Reed stuff, and he's like, "What's it all about?" And I told him, he's like, "Really, that all happened?" And he's like, "I'm gonna have to go watch that when I get home." So, Jesus Love You says starting the field of defense left too much out. I don't know, man. I mean, it's better they didn't. I mean, remember the last time they went through with all this, the jury's like, we didn't fucking understand, and half of them wanted to convict her. So I think it's better this way. I still think it's better they had left out all the shit about Brian Higgins ultimately, but are you ready back there? Okay.
What's up?
Hi.
How you doing?
I'm doing all right. Oh, hold on here. You're coming in a little hot, so I'll turn you down.
Always, baby.
That's about to say. There we go. You say something?
Yes.
There we go. All right.
All right.
Guys, Kurt from Uncivil Law. So what do you think? Like, what do you think of how it's looking right now? I know you said like 80-20 she gets acquitted, right?
In 20% to convict, I did like a half-hour sort of summary video about explaining why. If you read the Karen Reed convict portion of Twitter, there's a lot of you have to remember that some of those people might be on your jury, and so
yes. As I like to say, for most of them, the next interaction I'll probably ever have with them is like, "Yes, waitress, I'll have a cup of coffee, black, 2 sugars, and a piece of pecan pie. Thank you."
If you're asking for coffee black, 2 sugars, you're asking for contradictory things.
Well, no, I want my coffee black. Bring me 2 sugars, and then I'll decide what I do with it.
Okay.
I guess. But anyways, either way, if they're a waitress, they'll really know how to handle that then.
Okay.
Just bring me my pecan pie. But no, I do love now that there's the airplane crash in India. Some guy survived it. And they're like, see, you could survive a crash and nothing happened. And I'm like, you're right. And people have survived skydiving without a parachute. Therefore, we don't ever need parachutes anymore.
Yeah.
Yeah. It's yes.
In the strictest definition of crash, people usually survive.
Well, like an airplane crash, though.
Even in airplane crashes.
Well, big airliner crashes, not like little airplane crashes. But either way, people have survived getting shot in the head. That means I should go get shot in the head. I'll be okay. Or
couldn't do you any harm.
Yeah. Thanks, Kurt.
I'm here to help.
As I like to make the argument, you see these things, people who do motivational speaking, and they're like, you hear the motivational speaker saying, I dropped out of high school, did a lot of heroin, and now I'm a millionaire. That doesn't mean we should all drop out of high school, do heroin. Yeah. Well, I'll make $1 million, although maybe
I have a question for you, though, relating to the charge conference. If I understood what they said properly, and it was a little hard to hear, but it sounded to me like the prosecution would be happy to drop all the lesser included of count 2, the manslaughter charge, and it's the defense that wants lesser included of count 2. Yeah. I don't understand why under this situation you do that. I understand why in some situations you might do it. I don't know why in this situation
I totally know why.
Okay, please explain it to me.
Because Karen Reed probably there's enough there to believe she was driving DUI. There's 100% enough evidence to go for that.
But
she's even admitted to it.
Why present that at all? Because the top count manslaughter isn't a DUI manslaughter, is it? That's the one that lesser included. The top count is DUI.
No, it's because I think that way they can get the jury to say, look, let's at least convict her of something. She admits to DUI. Boom, she's guilty of DUI. We've therefore convicted her.
But it's DUI manslaughter.
Yeah, but they did the lesser included of just DUI though. And I think that's
you think they're looking for a lesser included as just straight DUI? You think that's what they're doing?
Yes, I think that's what they're trying to do.
Okay, if that's what they're trying to do, because that's what someone else had said, and I'm not I don't know. I listened to it twice and I wasn't able
It's
to.
hard. It's hard to
extract that.
tell. It's hard to tell. But we'll see the instructions tomorrow.
Yeah.
But I think that's what they're trying to go for, because that way, yeah, like she'll have drunk driving, and then it'll be like, well, then the jury can go, I'm going home. Screw all you people. And then we can all sit there.
If you want the throwaway compromise, don't you already have that with count 3 with leaving the scene of the accident?
No, because you'll probably get people who say there's no way in hell they're voting for that. Like,
Okay.
you might get people who say, like me, who would probably say, look, fine, convict her of DUI. That's all you got on her. And then that way they can say, fine, DUI. Boom. Karen gets a misdemeanor. Paul suffers. Peg suffers. All the people on Twitter suffer. It's just, and a great day all around. So.
Okay.
I think that's because really, I mean, it's clear she was OVI. It's just a matter of what else happened. I think, honestly,
I mean,
that's
that's a perfectly to be able to conclude that she was DUI. I think you can get there to beyond a reasonable doubt. I think that's fair.
Yeah.
Yeah.
So
sure, why not?
Scott says, "Hey, look, it's Kurt."
It is Kurt.
Yeah.
Feeling all pretty and charming.
Yeah. Yeah. Give her a DUI, whatever, and she'll be done. Yes. Yeah. DUI with time served, pretty much.
How about
Pretty much. These are.
How about we give her a medal?
Yeah. Yeah.
Yeah. Yeah. So, I mean, and I was also a little bit surprised that they didn't appear to at least orally address the issue relating to the complete / partial verdicts thing. I would have thought that would be a major issue. And
yeah,
it didn't seem to be
the
a
whole
thing.
Yeah, well, I listened to that, and I really want to re-listen to it again when I get a chance. But yes, the way she's doing it, it's like they almost want to, like, I'm surprised that both sides didn't look at her and go, do you remember what happened last time?
Yeah, really. Like, I'd want clarity on that point.
And she's going to be like, guys, I was like 3 or 4 margaritas in at that point. I don't remember nothing.
Yeah.
Auntie Baloney says she wasn't legally DUI. The regulations followed. That's not true.
Yeah, that's not true.
You are OVI. Like, your breathalyzer and your field sobriety test are icing on the cake. The officer, when he stops you, he smells alcohol. Your eyes are bloodshot and glossy. Your speech is slurred. You can't keep focus.
Yeah.
You're uneasy on your feet. And, you're just acting like a drunk person. Because think about it. Like, if they're driving you to the police station, and on the way there, the police station catches fire and burns down, cops don't go, fuck, I guess we can't charge you with a crime now. No. And they can't, and let's say there's not another police station for 5 hours away. Would they just go like, all right, well, I guess you're done? No. They could convict you based on their observations.
Sure. Or other evidence that would be available.
Yes.
Yeah, you can get there through other means other than you can get there other than a breath test or a blood test.
Yes, the breathalyzer just makes it beyond question, because then you could say, oh, look, it's 0.08 and she's over 0.08. But that's when an attorney goes, well, like, okay, well, where was the machine sitting? Did you follow the rules? Was there a radio next to it? All kinds of things that may interfere with it. Like, was a cell phone nearby? Cell phones can interfere with the machine. So there's all kinds of stuff you can do about that. But the machines give them a lot more legitimacy is the reason why they use them. And then real quick, BobTube says for $2 doodles, is Hank in trouble with the DA? Hence Lally is back.
I'm not sure what that's all about. That's funny though.
Yeah, it was interesting. If Lally gives the closing, that tells me Hank realized he pissed everyone off. I mean that's what I think. And then do you think Welcher begged him not to go back out there, or do you think Hank realized it was a bad idea?
I mean, that's what the Twitters are saying. The Twitters are saying that they said the Aperture people said they're out. They're not coming back.
Well, I mean, it's a little tough to do that when you're like, that's really, like, if that happened, that's really bad for your brand as an expert witness that you dipped out on your guy. So
you got to save face. You got to make a decision at some point.
Sometimes but that now you reputationally are known as, like,
you think they had reputation before?
Yes, Kurt, they are whores. Okay, whores. They are whores, and whores have one job. They're paid to leave after they get you off. And there are a number of insurance companies, prosecutors, defense attorneys who are going to need their services. So, no, whores will never run out of business to go through. Somebody will hire them. Quacks always have a spot. I think I mentioned this I mentioned this last night. But there's for attorneys, there's like a quack directory, like of doctors. You can find doctors who will basically testify to anything.
Nick Riviera from Simpsons?
Pretty much. No, I'm serious. Pretty much. I mean, in the middle of COVID, we were trying to find a doctor. I was trying to find a doctor who could help me say this lady killed her family members by exposing them to COVID. And I was talking back and forth with this guy for like a couple days trying to sort it out. And these people are quacks. So you could find an expert for anything, for the most part. No, you have to never. We're not talking about that. Egregious. Cerebral parasite for 10 subs. Let's go, chat. Nice support tonight, guys. Thank you. But yeah, I think ultimately there's, Hank has a lot of problems, and I think it's funny when you question people on Twitter, like. And I think Mark Betterow said it best. And I've never heard the term this way, but it's true. Your rebuttal argument gives you regency and position.
Yeah, of course.
When you're the last guy, it is absolutely amazing to have that. And to give that up is such a punt. You don't do it. Nobody punts like that.
Yeah, recency and primacy is like one of those basic trial advocacy 101 things.
Yeah, but he said regency, and I was like, I like regency better. But yeah, having the last word. I mean, that like Hank and Alessi would do that. They kept fighting each other. I want the last word. No, I want the last word. We never shut up until the judge says we're done. So this idea though that Hank was like, oh, this is good enough. No attorneys. When I was a prosecutor, it was never. I don't know if you heard me say it. I'd do a rebuttal argument of 5 minutes of my detective or somebody like, did you basically was that all bullshit? And he'd be like, yeah. And I'm like, okay, thank you. He'd look at the jury, nod, and sit down. That's all you have to do sometimes. So, but yeah, speaking of DUIs, Armand is right. You know where you could go and enjoy a DUI is at Stoney's Bar and Grill at 1580 Broadway Street in Rockville, Minnesota, chat. It is still, can you believe it, Kurt? It is still happy hour. And you know what they got tonight at Stoney's? $2.50 cans, Kurt. I mean, I don't know about you, but
the price keeps going up, man.
Hey, that's Biden inflation for you, dude. Tonight they got Jimmy C's food truck.
Excellent.
I mean, yeah, it's great stuff. It's bike night. Come on down and crank your hog out in front of everybody at the bar. It's great. It's great, guys. I mean, what more can you want? Go hang out on the patio. Guys, Stoney's serving Central Minnesota as the premier biker establishment for 30 years running. Go there, chat. It's a great time. Tell Cheeto I sent you. You got to keep hit the grind, man. We got to keep the grind going.
Please drink responsibly.
Yeah, yes, please drink responsibly. Stein Night Cologne says we don't choke slam our children at Stoney's. We only slam down beers. Yes. Grabbing them long necks, chat. That's what we do. Oh.
How have you been?
Cheeto or Cheeto? It's Cheeto. Cheeto, like the chip.
What were you saying? How have you been? You been good?
I've been pretty good. How about you?
I've been good.
How's your watch doing? Have you worn it yet?
The one that I made?
Yeah.
I still haven't fixed the stem, so I still have to fix that stem part.
Okay. Well, I say that was actually a lot of fun watching you make that. So I started doing. I think I've started doing it just because a lot of my chat have like a lot of different hobbies. I've had like one or two of them come on and what is it you're doing? Like, do your thing and we'll hang out. And it's been a lot of fun so far. So, cool. And having you on was kind of kind of inspired me to do that. So thank you, Kurt.
Excellent. Well, I'm glad to be a trendsetter. That's nice.
Yeah, it will. Yeah, it was great. Um, he says stream has lots of carbs. Thank you. So what are you up to after the, someday, Kurt, this war is going to end. What are you doing afterwards?
Well, I filed a notice of appearance today in a case, so I'm taking a property seizure case.
Nice.
So I'm working on that.
Some
so
real
that's gonna be
lawyering.
exciting.
Okay.
Yeah, that's gonna be fun.
I meant on YouTube here, but that's good too.
Yeah, that's gonna be interesting. And on YouTube, well, I'm probably gonna switch back to like daily edited videos for a while because
Okay.
I'm just tired. Like you do these every day, it's just
Yeah.
tiring.
It's a slog. It is, man.
So this is day 32 now or 33. I'm tired,
32.
man.
Yeah.
So I'm ready to take a break. So I'm just gonna try to
Yeah.
do basically like a story a day, kind of like sort of pop kind of story, sort of like similar to what Nate is doing. I think I've done stuff
Yeah.
like that before, and sort of try to do
Little-
things like that, like story that looks interesting, and try to do some news clips and maybe some light graphics, something like that could be fun.
Okay. No, that sounds like a good idea. I mean, it's not a bad idea to change it up a little bit because we are in we're getting to that point where it's like, what am I gonna do now? And I'm like, I'm kind of Karen Read it out. Like I kind of want to go do some other stuff. I totally understand because I'm very much there myself.
Yeah.
There have been a couple of Supreme Court cases. I'm sure you saw the one with the hey, we just call it discrimination now, which it's hilarious that and everybody's like, yeah, it's just discrimination nowadays. You're like, wow. And it's got to be really bad when I think it was Ketanji Brown Jackson gave the opinion on that one.
Yeah, it was an interesting day because like all the opinions were unanimous, and they were all kind of like yelling angry. They were like the Supreme Court was kind of aggressive that day. They woke up and chose violence. It was an interesting day of the docket. So I'm not sure what that was all about.
Well, yeah, and they let her do the violence. You're like, what? How does that work?
And then Justice Jackson wrote an opinion. I apologize. Justice Kagan wrote the opinion dealing with Mexico versus Smith and Wesson.
Yes.
Basically, like, yeah, Mexico, you can't sue you can't sue Smith and Wesson. Like, wow, okay, great.
Yeah,
awesome.
It's like yeah, suffer Mexico. It's like, well, they already do. They're in Mexico. They suffer. But yeah, it's very interesting how that turned out. I was not expecting that. I was expecting one of them just to re-inscree a little bit.
Yeah, not much screening there today.
Yeah.
So it's interesting.
Lately, yeah, no, I've been very impressed. Have you been following?
Yeah, it is June, so for those of you who don't know, the Supreme Court session ends at the end of June. So usually you get all the opinions by the end of June. I think last year, 2 years ago, they went into very early July for some reason, but you usually expect to see everything drop by the 30th. There's also, of course, the one dealing with the universal global injunctions, which is they took it in the context of birthright citizenship, but that's not really what the case is about. And so that's going to be very interesting to see what they have to say about that issue.
I love how they brought up the whole like, well, how would you feel if Joe Biden banned all guns? Like, okay, well, do you not agree that these are being abused? And it's like they are. And normally when this happens, we lose something. But is this like the one thing where we get to abuse the shit out of it? And you're like, it's okay.
Yeah, but trying to figure out from first principles like a rule that we can apply neutrally is challenging. I haven't been able to really do it. Not to say that I can necessarily think of anything, but trying to figure out what the rule should be is problematic.
No, I agree with that. Like, what would you do and how do you do it? And how do you make that bright line rule there? But I think they just, at the very least, they could say we heavily disfavor these. And it's not just Clarence Thomas saying that, but if all 9 of them say, look, you guys really need to fucking knock this off, I think is probably the best thing.
The district courts aren't going to get the memo. If they say, we disfavor them and you should take it really seriously, the district courts are just going to turn around and be like, well, this is the exception.
Yeah, this is very serious. This is very serious right now.
Yeah.
Well, heckin', it's like my heckin' Imagrinos. Like, all right, well.
So I don't know what you do if you basically have to automatically kick them all up to the Court of Appeals and only the Court of Appeals can issue these injunctions. Maybe that's the answer. At least that's something.
Yeah. I mean, that I guess, but I think that would be a way to do it. I guess I'm just worried because, I mean, it would streamline things because we could just, okay, fine, you grant it, and we're just going straight up. But you know what I'm going to tell you is the Court of Appeals is going to be like, no, we don't want this. They like being appellate judges. They don't want to deal with the slog of like running a courthouse.
Yeah.
That's why they're appellate judges. They don't want to deal with us commoners. That's why they love their
I
briefs.
thought it was so that I didn't have to deal with all those facts. That's why I want to be an appellate judge. Because I don't want to deal with all I don't want to deal with all the minutia. Because it's just too much bullshit.
Yes. If you get to, as long as you can make sure the court system doesn't collapse, you've done your job. Just distinguish everything. That's all you have to do.
Yeah, sure.
I mean, that's it. That is the beauty of it. So, Not So Goodland says, "Hey, Brennan may think Karen Reed is innocent after the last two witnesses. If he really thought that, he'd say, Your Honor, we dismiss all the charges." If he really thought that.
He's probably not allowed to do that.
I would then I'd say then fire me. I mean, if he really did, I look at him and say, like, well, he's already made his $200,000, so he already got that bag. It's like, then you fire me.
File a motion to withdraw. I can no longer in good conscience prosecute this case.
Yeah, and like do that on the morning of, and then be like, because like if they tried to make you prosecute it, you'd say, look, Rule 3.8, I can't do this in good faith. I'm out, and then you're done.
Yep.
So, that'd be great. That would be great. What do you guys talk about sending certified mail? I only send threatening letters to my congressman via mail. That's a joker.
Please don't
That's
die.
a joker. That's a joker, is it? I don't know. Israel just attacked Iran. Uh-oh. Really?
What else is new?
Well, I mean,
didn't they already do that like a while back, like 3 months ago or something?
Every once in a while they bomb the shit out of Iran, but like Tehran, but are they launching strikes into like Tehran? Because that's an issue. And then did they microwave any of the like Natanz or Qum, any of the nuclear sites? I don't know if they did. So you were told by chat the USPS is not the post office. Yeah, it is.
What else would it be?
Yeah. Oh, they did go. They went downtown. Whoa, buddy. Okay, some F-35s went downtown. That's awesome. We'll find out, but yeah, the post office is older in the United States. Well, that is too. I don't doubt that, but the USPS is the
Postmaster General is like the second highest paid job in the U.S. It's
Yeah, the USPS, the United States Postal Service, like.
Also, like the postal police, they don't get it. They don't get enough love in terms of like jurisdiction because their jurisdiction is the mail, and the mail goes everywhere. Yep. So, like, if you're looking for a law enforcement gang, the postal police is an interesting one for sure.
They're actually they're considered one of the non-scummy federal law enforcement too. Postal inspectors.
Yeah, that was the term I was looking for. Thank you.
Yeah, they actually have better reputation. Have I seen The Postman? Yes, I have.
He only rings twice?
No, The Postman. With Kevin Costner, the apocalyptic world. Where he, like, as a postal worker, they carry a bunch of guns and shoot people. So they go postal to save America. It's interesting. Yeah. Let's see. Postal Inspection Service, the one dudes I met. Yeah, they are pretty nice. Your biggest regret was not going from the military to the post office and getting 2 federal retirements. Yeah. I mean, that's the thing. It's pretty dope. Post offices is some of the best pension system in the federal government. Almost better than militaries, actually. Tom Petty was in The Postman, too. Yes, he was. Yes, it's Waterworld with horses. Okay, it's better than Waterworld. It sucks overall, but it is better than Waterworld.
Waterworld has grown on me as I've seen it more times.
The amount of M14 porn in the Postman makes it worth it. So, yes, the United States Postal Service is a pretty straightforward name. Yes.
Right. And it's also explicitly mentioned in the Constitution, the ability to make postal roads. It's one of the express constitutional powers. So, hey.
And they're actually, and this is something sovereign citizens like this to create, or they, there was a postal court actually that Benjamin Franklin had started in the 1700s. It went out, it disappeared very quickly, but it was an actual thing. And there's a couple of sovereign citizens that were running a federal postal court and trying to do liens and all kinds of weird stuff on people. But it was actually very interesting. Tofu Brain says, you love the M14. Who doesn't? I don't want to own one because they're disasters, but I think they look sick as fuck. But they're cool looking.
You mean the rifle?
Yeah.
Yeah, they're cool. They're very cool.
They look neat. You're telling me they don't look good, Tofu? I mean, like, yeah, I'd rather have like an FAL or a G3 if it was like put in work time, but it's still cool looking.
What's your problem with the M14?
It's very not reliable. It's got a lot of reliability issues, and they have a problem when you try to accurize them. They twist and cause a lot of issues. So you have to constantly make sure that it stays, you know, in the proper accurization setup. Where like a G3 or an FAL, just you make sure it's not broken and it shoots. And you know,
how about we go M1?
The M1 Grand, the M1 Grand's fine. M1 Grand's 100% fine.
Yeah.
The M1 Grand has a lot of.
It goes ping when it runs out of ammo.
Yeah, but the M14 is an M1 with a lot. Yes, it's got a detachable magazine. Then it's got a lot of problems that they added onto it. So, yeah, it has a lot of QC issues. And yes, as a callback to the LA riots, it's no Daewoo. Yes. Bella says, "Oh, they struck the nuclear facilities like Natanz." That's the big one. That's where they have they built into the hillsides.
Okay, that could be a thing.
Yes. That's good. Might need to prep for the show tonight. We will be in a second here, chat. We will be in a second. So.
You going to be doing verdict watch?
I mean, I probably will a little bit, but I'm going to be kind of like out and about doing stuff. So, like, I'll be around. So. And Anna Wall says accurize. Yes, the M14, if you Google how to accurize one, there's a lot of work involved in it where you bed it down and you bed the action. And the problem is the action beats the shit out of itself and it ruins the bedding. You have to do a lot. AP says an M21 will smoke a G3 for accuracy. Shoot it 1,000 rounds and tell me who's still accurate after 1,000 rounds. That's the answer. That's the answer. I'm gonna get a sniper Kata and Keanu from Denny's. Oh, there you go.
What are they at Denny's?
No, but Keanu's doing Gabe Hoffman tonight, so it'd be like live from Denny's. We are covering Keanu.
Yeah.
No, Chad. I'm gonna be doing my show as normal. We've got some stuff to talk about tonight. We got some interesting stuff actually. Karen Reed's over. Harvey Weinstein.
I could
had a bad day.
There was some apparently some drama though in the jury. Did you see that? With some threats apparently. So.
Yep, there's a couple things we'll be covering. But yeah, guys, that'll be at 8. That'll be at 9:30 tonight on the show here. It's gonna be great. The guy who's saying "Watch me whip, watch me nay nay," he actually was sentenced to 30 years in prison for killing his cousin. What's
is that the stanky leg portion of it?
The Cilento. That's the guy. No, I don't think so. I don't think it's the stanky leg portion.
You're going to be doing a lot of stanky leg in prison.
Oh yeah, I'm sure he will. I'm sure he will. Well, the stanky leg will probably get done to him. He's not a very big guy. So yeah, today was pretty eventful overall. Eric says, "What happened to the jury? You're gonna have to come watch the show, and I'll tell you all about it." That's out. See how that's how it works.
Teaser.
Yeah.
Yeah.
Then also tonight, I guess as a Rekieta update, Nick Rekieta slapped Monty.
Now,
I bet some of you guys didn't know where I was going with that one.
Now, please, did Rikita at one point seem to speak against those slap motions, or am I misremembering something?
I don't know. He's gone against a lot of things. He said it all kind of blends together at this point. If he said he was for it at some point, he's probably against it. So I'm just saying. I'm just saying. So
He's
that will
lose
be
that lawsuit.
I think probably at this point, yeah, he will. Especially, it's like one time is a mistake. When you say it 500 times, it's like, well, yeah. Oh, he said during the Vic saga he didn't like him. Okay, that's interesting.
Yep.
So he choke slapped Monty. Oh my god, I love this chat. Some days I love this chat.
Your chat is degenerate.
It's something else. But it's something else. That's all I can say. All right, Kurt. Well, I think we're going to wrap this up here. We're going to get ready for the 9:30 show. So,
excellent.
Anyways, guys, Kurt, Uncivil Law. He'll be definitely doing the verdict watch. He'll be around. He'll be available for it. Guys, find him over at Uncivil Law here on YouTube, Uncivil Law on Twitter. And yeah, Kurt,
Thanks.
anything else?
I hate you too, chat. You're the best. Bye-bye.
Bye, Kurt.
All right.
All right, guys. Friend of the show, Kurt from Uncivil Law. You guys all take care. And oh, Not So Goodland says, oh yeah, innocent last two witnesses. Chugi says Israel just attacked Iran. Lisai. I feel your sentiment there. So, chat, we are all caught up. Karen Reed's trial is over. On to closing arguments tomorrow. We'll cover tomorrow night, as always. And yeah, so just remember until next time, chat. Just because you did it does not mean you're guilty. And we will be. Am I the AI moving on? Okay, my camera's flashing. 9:30 tonight. We will do the trial show, the crime show, and yeah, Karen Reed still not guilty. Chat. Good night, chat, guys. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just cause you did it doesn't mean...
Hella just got here. Sorry, Hella. Suffer, mate. Sorry, Hella.
Guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes it was. He even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potential